Making Courts and Mediations Accessible for People with Disabilities. David Lepofsky, Chair, Accessibility for Ontarians with Disabilities Act Alliance. Delivered at the Osgoode Hall Law School, January 21st, 2014, as a Roy McMurtry Clinical Fellow.
What I'd like to talk to you about for a few minutes is addressing the barriers that people with a mental or physical or sensory disability might face in the mediation process. So we're anticipating that there's a court or tribunal administrative proceeding. They've decided to go to mediation to see if they can settle the problem. A mediator is appointed, and one or more of the participants in the proceeding has a physical or mental or sensory disability. It may be one of the clients, it may be one of their support people or their spouses or friends if they're taking part, or of course it could be the mediator themselves or an arbitrator, or it could be the lawyer representing one of them. Primarily though, I'm going to focus on the parties. If it's a matrimonial thing, the spouses. They could face barriers in the mediation process, and we need a strategy to deal with them. There's a good place to turn to get ideas about what those barriers are and how to fix them. Let me tell you about that place. Let me tell you a bit about what was learned, and then let me give you a few ideas of the kind of barriers that can come up and how they might be dealt with. In 2005, the Ontario Legislature, through the enactment of the Accessibility for Ontarians with Disabilities Act, committed the province to become fully accessible. At that time, the Chief Justice of Ontario was Roy McMurtry. I am now honored to be the Roy McMurtry Clinical Fellow at Osgoode Hall Law School during this term. And so the coincidence of talking about what he did to help out is delightful. Chief Justice McMurtry was and is a visionary individual, and he announced in 2005 that he supported the government's plans to require Ontario to become fully accessible by 2025, and that the courts should do their part. See, the courts, too, have to become fully accessible. So Chief Justice McMurtry appointed a joint committee of the judiciary, the government, and the legal profession to identify the barriers that now exist in the court system and to offer an action plan of what to do about it. It was conducted under the able leadership of its chair, Justice Karen Wyler of the Ontario Court of Appeal. I was privileged to serve on that committee. We reached out to the legal profession, the government, and others to figure out what kind of barriers took place, and the final Wyler Report identified them. And we also came up with a vision of what an accessible court would be like. And we, in the Wyler Report, identified that. And finally, we offered an action plan of how to get from a court system full of barriers to a fully accessible court system. That document that resulted from the 2 years of work was called the Wyler Committee Report. Wyler's W-E-I-L-E-R. It's available on the Court of Appeal, and if anybody wants to see it or they're watching this video, you just Google Wyler Report, Disabilities in Ontario, or go to the Ontario Court of Appeal website and you'll see the report posted. And the report stands the test of time. It got it right. And one of the things it did was to propose that a permanent committee of the bench, the bar, and the government be set up to oversee its implementation. The courts and the government did that. That committee still exists. I serve on it as well. It's called the Ontario Courts Accessibility Committee. And through the work of the Wyler Committee from 2005 to 2007, and the work of the Ontario Courts Accessibility Committee from 2007 to the present, we've learned a lot. There's been a lot of progress. There, of course, is much still to be done. One of the things that we learned is that there are a number of recurring barriers in the court system. And I'm not talking about barriers to getting a lawyer or justice barriers or inadequacies in the law. Those are all important issues, or inadequacy of legal aid coverage and so on. I'm talking about a person's involved in a court proceeding as a client, a lawyer, a witness, a prospective juror, a judge, court staff, whatever. They face a range of specific barriers. Let me summarize them and then let's see what we can draw on this for the mediation process. First, we found there are a lot of physical barriers. Some of our courts are old, and they may have steps to get into them or a step to get into a jury box or a witness box. They may not have sufficient accessible facilities throughout the building and so on. We also found that there were communication barriers. Section 14 of the Canadian Charter of Rights and Freedoms, nobody reads Section 14. They kind of go from 13, not incriminating yourself, right to 15, equality, and they never look at it. But it guarantees a right to an interpreter to people involved in court proceedings if they're deaf or if they don't speak one of our official languages. Of course, there's also official language entitlements. And yet, because of sign language shortages and so on, there are problems that people who are deaf or who are deafened or who are hard of hearing getting access to appropriate interpretation supports. People with vision loss or dyslexia can face barriers in reading court forms or reading printed material that is used in court proceedings. People with intellectual disabilities and some other kinds of disabilities find the language we use impenetrable. Of course, lay people with no disabilities find the language we use impenetrable. For them, plain language, wherever possible, is critical. Interestingly, the whole direction in legal writing now and for the public, for clients, is plain language. To the extent the legal profession fails to live up to that, we're actually hurting everybody, but we're especially hurting folks with certain kinds of disabilities. We also found a range of other kinds of barriers. I will leave it to you to read the Wyler Report to get more about that, but let me talk about transposing this to, pardon me, what did the Wyler Report recommend? They recommended the government develop a series of strategies to deal with this. They proposed, the government has adopted this, that every court facility should have a disability accessibility and accommodation coordinator, a one-stop shopping to go if you need something fixed. They proposed that judges and lawyers need more training on this, and there's been an increase in training for judges and lawyers. For example, the Law Society, I've really been honored to chair 2 successive continuing legal education webinars by Law Society. We have a 3rd one coming up in May of 2014 to deal with these issues. And there's training for judges on these kind of barriers too. As well, it was proposed that the government should put in place specific strategies to address recurring barriers and should communicate the availability of these to the public. So now let me turn to the mediation process. The same barriers that come up in the court process can come up in the mediation process. Dealing with them may be, in a sense, administratively a little more challenging, not because they're any harder to fix, but because the mediation may be under a mediation organization or company. It may be under a government department. It may not be as under the same kind of central control as the Ontario government has. The Ministry of the Attorney General has an entire division called the Court Services Division that can put in place strategies to be available court-wide or province-wide to try to deal with some of these barriers. Nevertheless, here are some practical suggestions. Number 1, it should be built into any negotiation/mediation or arbitration process from the beginning that parties and other participants be solicited right up front. Does anyone have a disability that requires an accommodation so they can fully participate in the process? One thing we've learned through the court process, through implementing the Wyler Committee, is that it's absolutely essential that that question be put as early in the process as possible. You don't wait for the first day of trial to walk in and say, I know it's an 8-week trial, but we need sign language interpretation every day. You're not going to get it. You're going to end up delaying the trial. The earlier the request is made, the easier it is to plan for it. And participants in the mediation process, especially lay participants, will not know that they can ask. And they certainly won't know who to ask. Organizations that provide for mediation should have this inbuilt, either in the forms they use or in the online resources they have or whatever. But it's also important that anybody actually conducting the mediation should, as part of their introductory remarks or even the materials they send out before the mediation begins, identifying if there are any accessibility needs and trying to connect people up with whomever they need to solve them. Drawing on the court experience, let me give you just a series of examples. If there's a person with vision loss or dyslexia who can't read printed materials, there are ways, many ways, to translate printed materials into an accessible format. And you don't need to know Braille to do it. Many of us use a computer, as I have sitting in front of me, with a screen reader on it. It's a software that will read the text on the screen. But if the material is sent to us in a format like PDF, we may not be able to read it. It's important to ask the individual, do you have a computer that can read these to you? Can they read Word? Do you need HTML? There's a number of formats that are easy to access, like Word and HTML, and PDFs can be awful. There are some who claims PDFs can be accessible. There are features you can turn on. They help with accessibility, but it's still a rearguard battle. It's better not to use that format wherever possible. Frankly, not to use that format, period, when providing information to us. For some people with vision loss, they have low vision, and they need large print. You can expand the information on the page, print it, or there are people with low vision who have magnifying technology, so they put the document under a camera and it comes up on the screen, substantially enlarged. It's all a matter of planning in advance. When it comes to people with hearing loss, they fit into three categories. People who are deaf, i.e. born with no hearing. People who are deafened, i.e. people who had hearing and lost it. And people who are hard of hearing, people with some but not complete hearing. Depending on which you are, and even within those groups, people use different communication supports. Some use sign language, and there's different sign language. There's American Sign Language for English-speaking people, LSQ for French-Canadian people in Canada who speak French. For some people, they don't use sign language, often deafened people or hard of hearing, and they may prefer to have captioning, real-time captioning. Same people who do some real-time transcription can provide real-time captioning. Similarly, some people use lip reading. It's important to identify, you don't just say, oh, they're hard of hearing, they must read lips. It's important to canvass with the individual which support works for them. With any disability, different people with the identical condition will use different supports. There are people with other kinds of communication disabilities where they have difficulty processing or communicating, not due to hearing or vision. And there's a whole field called AAC, or Augmentative and Alternative Communication, with professionals who can provide communication supports. Obviously, physical barriers are an issue. You need to conduct a mediation in a building that's fully accessible, with washrooms that are fully accessible, that is accessible by accessible transit, or has accessible parking nearby. Don't assume that all exists. And don't assume it exists even if the building has signage saying accessible. And even if it has signage, even if it's accurate, you got to be careful, because somebody could pull up and find out that somebody shoveled a pile of snow right at the foot of the ramp. And therefore the accessible entrance isn't accessible at all. Yes, these things really do happen. People with intellectual disabilities may need support, and some other disabilities may need support people, may need plain language support, assistance. People with different kinds of disabilities may have fatiguing conditions, or due to medication they're taking, there may be times of the day that are better for them. That may involve working out scheduling arrangements to best accommodate their capacity to fully participate. If you go to the Wyler Report, you'll see other examples. I've just given a few because this is just a short presentation. But the best way to solve all of this is as early as possible to ask the individuals to explain, here's what the process is like. Are you going to have any accommodation needs? Please let us know. And let us know which accommodations best meet your needs. The sooner you know that, the sooner you figure it out, the sooner it can get implemented. A high burden rests with lawyers. Lawyers aren't used to asking their clients about this. But it's important for any lawyer that's going to take part in any court or mediation process or any litigation process to find this out as soon as possible. And in the court process, it goes further because you need to know about the needs of witnesses and others who you may be calling to testify. Let me conclude by saying that in the years I have spent training lawyers and judges on the issue of accessibility to the courts, I have been met with a unanimous tidal wave of support. The things that we often hear back go like this: I've never thought of this before, I didn't know this was going on, thank you for letting us know, and what else can we do? A judge or a mediator can't be expected to be an expert on all disabilities, but they can benefit by simply asking or having the lawyers do the kind of solicitation I've mentioned to enable them to proceed and to ensure full participation and full inclusion.